All right.
Recording. All right, welcome everyone. We're going to start a review, and we start the review with what is a republic? Who wants to tell me what is a republic?
Mixture of an aristocracy, a monarchy, and a democracy, which has to have a constitution, and it's kind of run by the people.
Good. Anybody want to add anything to that?
It is ruled by law.
Okay.
It concerns public matters, res publica from the Latin, things public. And in our situation of the U.S. Constitution, it is a hybrid form of government, which, as Bob said, contains elements of democracy, monarchy, and aristocracy. The democracy being the House of Representatives, the Congress, the Senate, somewhat of a democratic, but it's more aristocratic because they have elections every 6 years. Your judiciary is the aristocracy. They serve for life. And
No, they don't. They serve for good behavior.
That's right. She's right.
Name me a Supreme Court justice who has been removed from office for bad behavior.
Samuel Chase.
There you go.
But we will continue on.
Holy cow,
You're
John!
on a roll, Howard. Keep going. You're on a
Oh,
roll.
wow, I didn't know that.
Don't let the little people bother you, Howard. Just keep going.
No. I wanted to review this so we could get on to the topic that interests me more, which is the amendments. So we've already been over this multiple times. I'm not saying I'm bored, but I want to be more excited. Let's put it that way. Also, the president is a monarch. Though he can be removed for bad behavior,
Yes.
Marty.
Every 4 years.
Yes, that's
At
called
least.
elections. Yes.
Right.
And,
Marty, I'm going to mute you. Marty, I'm going to mute you.
Marty, you're on fire today.
That's all I got. Let somebody else take the plunge.
Yeah, actually, Teresa was about to say something before Howard squelched her.
Oh, I was just going to mention the aspect of being able to check and balance each other
Good.
with the three,
Good. That's exactly right. That's exactly right. All right. You all get gold stars for today. Thank you very much. All right. And the U.S. Constitution sets up a republic. And you can tell that it is, and as with anything that is made by people, it is formed by a sovereign. It is not, and you can tell in the preamble where it starts off in the beginning, we the people, and then it says why they're doing this, and then do ordain and establish this Constitution for the United States of America. That is the formula of a particular type of document, which is called not a compact, which is an agreement, but it is a charter in which a sovereign creates something for the benefit of the sovereign. The most notable charter that we know about is the Magna Carta, which is the Great Charter, and it starts off King John, Lord of Ireland,
Blah, 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 blah.
all this.
England, Wales, and Scotland.
England, Wales, and Scotland, all the rest, and Duke of so-and-so. And so I'm going to establish all these things. And that is what this starts up as, we the people. And it's saying, therefore, it is the people that are the sovereign in this. There's not a king. It is the people that are setting this up. And that's why it also is called res publica. It's a thing of the people.
The Magna Carta was signed at Swords Point. The nobles had rebelled. So
and in fact, they had to renew it about every 2 or 3 years. They had to keep going back to that sword point to get it
good
there.
Good them.
And so then the Constitution starts off and it says, okay, basically we're going to have these three branches of government because that's exactly what we were talking about. There's an aristocratic part, there's a democratic part, there's a monarchical part. Article 1 talks about the democratic part, which is Congress. Anything that goes on in Congress requires a majority vote. And that is why you look at that and you go, this obviously a democracy. That's you have two houses. One is the democracy of the people, which is the House of Representatives. The other is the democracy of the states, where a majority of the states have to agree to something. And that's what the Senate does. It's the democracy of the states. Article 2 has to do with the monarchy part of it. It talks about the president and all the things that he can do, and his word is how things get done there. That's how you can tell that's a monarchy, because it's not, he doesn't have to answer to somebody else. He just when he says we want to do this, then that's what we want to do. Now there are checks and balances with other parts of the government. And then Article 3 talks about the judiciary, which is the aristocratic part. There are a number of things that kind of point to this being an aristocratic part, because the real idea of an aristocracy is that those who are in the know, those who are capable, will take care of those who are not capable. So you have some guy who's brought up on charges, and he's got the whole government up against him. He goes to the court, or is taken to the court, for the court to protect him while determining whether or not he's done right or wrong. It is very aristocratic piece of government. Another thing that makes it really look aristocratic is, if you've ever been in court, you notice that the ones who can speak are the ones who have been trained in the law. They're the ones who have the special knowledge. They are the nobles, the dukes, and the princes within that court system. And you, as a commoner, are not allowed to speak except under particular situations.
You could represent yourself pro se.
You can't.
But I really wouldn't advise it unless it's small claims court.
Right, and even there, it's questionable. But as the lawyers say, anyone who would represent himself has a fool for a client. So,
well, I speak right up to that, but I have defended myself in traffic court and won a couple of times.
Well, good, Howard. That's good. So
if the police officer doesn't appear to testify against you, you won.
That's right. You win automatically. Article, and I've gone to traffic court exactly with that in mind. However, the officer did show up. Anyway.
Yeah, well,
I almost had him beat too, but because I'm not a lawyer, I did not observe this little nuance, which would have been nice. And the judge said, well, you didn't address that, so no.
What did you not address, John?
We're not going to go into it because we've already gone this far. At any rate, so that's Article 3 is the judiciary, which is the aristocratic part. Then Article 4, because we have a really special kind of situation here, where we have not just these three branches of government, but that are on the same level. We also have levels of government vertically as well, because you have the national government and you have the state government. So you have to be able to describe the relationship between them as well. And that's what Article 4 is about, is the relationship between the states and the national government. Then Article 5 is, you're going to want to amend this from time to time. Under the Articles of Confederation, it was absolutely impossible to amend it, and they never could, because Rhode Island would always hold out. So they said, we're going to figure out a better way of doing it. That's what Article 5 is the procedure for amending it. It's not impossible, but it is difficult. Then Article 6 has to do with the supremacy of United States law, where if there is a state law that that contradicts a national law, the state law is subservient to it. However, that assumes that the national law is only going to be applied to those powers which we, the people, are granting to that government. So if you have some a difference between a state law and a national law having to do with, say, the military, since the national government is given charge of the military, the national government rules. However, if you have another one that has to do with, say, stop signs, and the national government has not been given a power to do something with stop signs, the state law is going to rule because the national government should not be in it at all. So, but it talks about that, and there's a few other things like there's no national test, no religious test to be in office, and a few things like that, which kind of bind the country together. Then Article 7 is the process for adopting this. And then we have the signatures of all the people, and then it goes out to the states. The states then adopted it. When they adopted it, though, they went into conventions and they said, you know, we like this Constitution, except there's some problems with it. It doesn't address the things that are in the Bill of Rights that we have as Englishmen. We have certain rights which have been which we have become used to for over the last 100 years, and we want to make sure that those are guaranteed. Those who wrote the Constitution said, but in the Constitution, it doesn't say that they can do anything about those things. So since they're not allowed to go into that, we don't need to say that you have these rights because the government is not allowed to. And the states said, New York and Virginia and Massachusetts said, yeah, no. Just because you didn't say you can't doesn't mean that you're not going to try. We want it in stone. So in the very first Congress, Madison was elected. James Madison was elected to the very first Congress, and he won he won his seat based on the promise that he was going to put a Bill of Rights up, a series of amendments to the Constitution for a Bill of Rights to go out to the states to be adopted. That is what he did in the first Congress. They got 13. They melted down all of the suggestions. It may have been like 200 different suggestions of different rights that needed to be protected, and Madison put them into 13. Congress looked at them. They said, no, we'll send these 12 on. They sent 12 of them on. 10 of them got approved. And that became the Bill of Rights. And that's the first 10 amendments. It starts with the freedom of religion and so on. And we've covered those in earlier meetings. And now we're up to, I'm going to share my screen, Amendment 11. Are we good with that? Actually, before I share my screen, are we good with that? Have I lost anybody?
Nope, we're good.
Okay, good.
That was a very good review, John. It's been a couple of weeks, and that was very thorough.
Thank you.
Thanks.
Okay. And Amendment 11 is on your screen. You can see it okay?
Yes.
Okay.
Yes.
All right. So, I'll tell you what, let's just read what the amendment says, and then we'll talk about why it was and what difference that makes today. Bob, you want to do me? You want to do that? I may stop you in the middle. I'm not sure.
Okay. The judicial power of the United States shall not be construed to extend to any suit in law or equity. commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state.
Good.
Hmm.
Now, you may recall, I can go back to it if we have to, but in Article 3, Section 2, it talks about all the different kinds of cases that the federal judiciary can deal with. And it talks about if you're suing, have one state sue against another state. If a state is a party in another suit, so on and so forth. And it has all these things. And one of the points was if the subjects, if the citizens of one state or the subject of a foreign state sue a state, it gets tried in federal court. And there was a case in the 1790s, 1793, I think it was begun. Marty, would you like to talk about this one? Because I know you and I had an email about this back and forth.
Yeah, but I don't remember. That was like 3 weeks ago.
Okay.
It was, yeah, it was Chisholm versus Georgia, 1793, where Georgia hired this guy to make stuff for Georgia. And then they didn't pay the guy. And when he died, his heir sued Georgia, and they actually got it, but then that was overturned by the 11th. Well, I mean, that kind of a thing, right?
Yes, yes, exactly right. So Chisholm was one of the was the executor of the estate of this fellow who lived in Georgia. Chisholm actually lived, I think it was in Pennsylvania or something
It's
like
Louisiana, I think.
that. Yeah, he lived in a different state.
Yeah.
And Georgia had contracted with and bought, I don't know what it was, horses or something or other, from Chisholm, the original guy, to help prosecute the War for Independence.
South Carolina, Robert Farquhar.
Okay.
But clothing from Robert Farquhar, South Carolina merchant.
Okay, good. So Chisholm said, Chisholm then wanted to get the money because he was the executor of the estate. But in order to get the money, he couldn't. Since it was a citizen of another state, he had to go to federal court to do it. The federal court then, I guess, ruled in his favor. I'm not sure.
That's correct.
Is that right? Okay. And Georgia had to pay. However, what this did is it brought to light that the states were suddenly under the they were no longer sovereign in this area. And one of the important points of being a state, of being a government, of being a sovereign, is that you get to choose who sues you. And if you don't want somebody to sue you, you can say, no, I'm not going to sue you. And there's all kinds of reasons why that's a good idea. You know, if the king is chasing out an invader, he doesn't want to have to stop at every farm and be sued because he's trampling the crops of that farm. Hell, he's chasing an invader out of the country. You just don't want him to have to be bothered with this in the middle of when he's doing something that's important. So there's good reasons to have what is called sovereign immunity, that the sovereign is immune from suit. When they in Article 3, Section 2, it says that the citizens of a state sue the state in federal court, which means that the state has just given up that piece of sovereign immunity, and that was just one step too far. So they said, so they then passed this amendment to remove, basically it removed that clause, that little clause from Article 3, Section 2. Does that make sense?
Yep.
Okay. All right. Basically it comes down, a state can only be sued in its own courts. And that's what it is. If I in Oregon don't like something California did, I have to go to the state court. I have to go to California State Court. All right. Ready to move on?
Yep.
Yes.
Yep.
All right. Now this is
Long.
1804. This is a big one here.
Oh, my God.
The 12th
One
Amendment.
paragraph. Holy cow.
Yes, indeed. However, you're going to recognize it from Article 2, Section 1. It's basically a rewrite of Article 2, Section 1. Because in the election of 1804, I'll just start with why they did this. In the election of 1804, no, I'm sorry. In the election of 1800, under the original Constitution, you had the electors meet and they'd vote for two people for president. The guy that got the most votes would be president. The guy that got the second most votes would be the vice president. However, by 1800, parties had started to be forming, and you had the Democratic Republican Party, and they put up Thomas Jefferson as their guy, and kind of Aaron Burr was going to be his vice president. So the electors all voted for Thomas Jefferson and Aaron Burr. So those two had the exact same number of votes in the Electoral College. So they said, okay, well, now according to Article 2, Section 1, what you do is it goes to the House of Representatives. And the House of Representatives had to choose, is it going to be Thomas Jefferson or is it going to be Aaron Burr that's going to be president? And they went through 36 different ballots until I don't know what kind of backroom deal was struck, or whether Aaron Burr just upset somebody too much or something, so they switched their vote. But finally, after something like 36 ballots, days and days of balloting.
I think that they agreed for Jefferson. I think wasn't that the Northwest Territory Purchase involved in that? They would go ahead and do that and give it to Jefferson. I may be wrong.
Not that I know of.
Okay,
That does not sound familiar to me.
okay.
Marty, I think that had to do with the establishment of the Capitol on the Potomac.
Oh,
And then
okay.
I think there was some bargain in that regard.
Okay.
Oh, yeah, no, yes, right, okay. Yeah, and I'm not right up on that story. So at any rate, though, in 1804, they in the election of 1800, they realized that they had this problem, and they didn't want to have every 4 years go through this horrendous House of Representatives 36 ballots thing. So they said, all right, we're going to change it. We're going to change the way that basically the Electoral College works. And they changed it to this. So Marty, you are on my hit parade here.
Oh, no.
All right,
Okay.
so I'm going to probably stop you at some point along the
I
way.
figure. Okay. So the electors shall meet in their respective states and vote by ballot for president and vice president, one of whom at least shall not be an inhabitant of the same state with themselves.
Good. So originally each elector had 2 votes and they'd vote for 2 people for president. Now they've changed it. You got 1 vote for president and 1 vote for vice president. So that you're never going to run into this problem again of the 2 people getting the same thing. Okay, continue.
Okay.
They shall
They shall name in their ballots the person voted for as president, and in distinct ballots the person voted for as vice president. And they shall make distinct lists of all persons voted for as president and of all persons voted for as vice president, and the number of votes for each.
Okay,
Which
good.
list?
Okay, so when they vote, this is basically what I said, or basically you got 2 lists, one for president, one for vice president. You see how that's different? It used to be one big list for president. And,
So
and so you can end up with Thomas Jefferson and Aaron Burr having the exact same number of votes. All right. And I think we were right here on the number of votes
vote for each.
Yeah.
Which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the president of the Senate.
Okay, now that's verbiage that's lifted directly out of Article 1, Section 2, no change. Or Article 2, Section 1, I'm sorry. No change. They're doing exactly the same thing. The only thing that's changed is you have two lists instead of one. Okay, continue.
The president of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be the president, if such number be a majority of the whole number of electors appointed.
Yeah, which is basically it's the same as we originally had. Except that now they're going to do two different distinct lists.
Okay.
Okay.
And if no person have such a majority, then from the persons having the highest number not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately by ballot the president.
Okay, good. So they're going to take the top 3. That's pretty similar to what was in Article 2, Section 1. I don't remember if it was 3 before or not, but I think it was 5 before, but now it's down to 3. Okay. And so they choose by ballot the president, but in choosing.
Why don't we let somebody else? It's a long one. Why don't you let Howard take it or something?
Oh, well, actually, Teresa is next on my hit parade.
All right. But in choosing the president, the votes shall be taken by states, the representation from each state having one vote.
Good. All right. So it's by state. So you got 13 states. You're going to basically have 13 votes. But all of the representatives from Massachusetts get together and decide what their vote's going to be. And all the representatives from Vermont get together and decide what their vote's going to be. Okay.
A quorum.
Yeah, a quorum. Good. Continue.
A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice.
Good. Okay. So if you have 50 states, in order to have a quorum there, you have to have 34 states represented. You have to have 34 states there. But still, in order to actually make a choice, you got to have 26, a majority of what the whole number is, not of the quorum.
Oh, okay.
So, okay, good. Okay. Are we good with that, everybody, or is anybody dropped off? Or
Good.
No, I'm good.
We're good.
we're good. Okay, good. All right. If you remember where we are, Teresa, please continue.
I don't know.
And if the House.
House.
Yeah.
Oh, there it is. Okay. And if the House of Representatives shall not choose a president whenever the right of choice shall devolve upon them before the 4th day of March next following, then the vice president shall act as president, as in the case of the death or other constitutional disability of the president.
Yeah. Now this is a little different from Article 2, Section 1, because Article 2, Section 1 did not have an inauguration date because they didn't know what the inauguration day was going to be. And when they were starting up the country, it just so happened that the 4th of March was the day that they inaugurated first time George Washington. So it was the 4th of March from then on until the 20th Amendment changed it to January 20th. And when we get to the 20th Amendment, we'll talk about why that was. And this is just making the vice president the president if he can't do it. So
Now that would be assuming that there was no conflict in the vice presidential choice, correct?
yes, it would be. Yes, it would be.
Yes.
So And we'll continue. Are you going to continue, Teresa?
Yeah,
Okay, I think this is where you are.
right there, yeah. The person having the greatest number of votes as vice president shall be the vice president, if such number be a majority of the whole number of electors appointed. And if no person have a majority, then from the two highest numbers on the list, the Senate shall choose the vice president.
Okay, I'm gonna move the page here.
All right,
Okay. So this is very similar to the other one, to the selecting the president. If you don't have a good choice, the House of Representatives selects the president, but
Only 2 instead of 3.
the Senate selects the vice president, which is the same as it was in Article 2, Section 1.
all right.
And the Senate shall choose. Okay, and again, we have quorum. Okay, go ahead.
A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice.
So they're not voting by state here. They're voting by senator.
Yes.
All right.
Okay.
Wrap it up, Teresa. Thank you very much. Continue.
Okay, but no person constitutionally ineligible to the office of president shall be eligible to that of vice president of the United States.
All right.
That's a good one,
Yes, it is a good one.
because with Kamala Harris, she's not eligible to be be president.
Oh, that would be
Whether anybody does anything is something, but
Yeah.
she's not eligible to be president.
exactly right. It's whether anybody's going to be willing to do something about it or not. Exactly.
Wow.
I have heard that too, Marty, but what is the precise reason?
Because she's not she's got dual citizenship. She's not a citizen, a natural born citizen of the United States, and she's got dual
Oh.
citizenship.
That's right. Her parents became citizens after she was born.
Right.
What is the other country that she's a citizen of?
Puerto Rico, Costa Rica,
Jamaica.
Jamaica. There you go, Jamaica.
Jamaica, Mon.
Oh my God.
Well, could she renounce her citizenship?
She would have to. But
Okay.
Wait, she was born in Jamaica?
No,
no, she was
she
born
was
here.
she was
But
born in California. She was born in California, but her mother is Indian from India,
Right.
and her father is Jamaican.
And she would have to renounce her Jamaican citizenship.
Well, I don't know. The problem there is with the definition of natural born citizen. And the original definition of natural born citizen is a person that's born in country to citizens.
That's correct.
And even if she renounced some other
That's
citizenship,
true. She's still not.
she would still not be. See, but that's the original definition, and it depends then upon, whether or not the courts would enforce it, whether or not it would kind of be allowed. It's not. Christian looks like he wants to say something about that.
No, I'm going to stay quiet on that issue. There's a lot of definitions that get floated around here in law that don't necessarily match with the Constitution. So
That's true.
Okay, good. Yeah, and I've written a number of emails about it, and it goes back and forth, and really what it comes down to is whether or not the people are going to allow it to occur, because that's always what it comes down to.
Constitution of the people.
Is whether or not the people allow it to occur. All right. So anyway, that's the 20th. That's the 12th Amendment, having to do with the Electoral College. We good with that?
Yep.
Ready to move on?
Yeah.
Yeah.
All right, here we go. The next one is the next batch of amendments, and it's funny. These amendments to the Constitution tend to come in batches. And very peculiarly, they come in batches about every 50 years. The Civil War amendments, or what are also called the Reconstruction Amendments, were after the Civil War in the 1860s. Then the next batch of amendments are in the 1910s. They're the progressive amendments. We'll get to them. And then the ones after that are in the 1960s. So it's like every 50 years we have a batch of amendments, which I think is, and if we had a batch of amendments now, they would have been in the 2010s. That would have kept the cycle going. But we didn't get them, and my opinion is that that's one reason that we see so much unrest these days, is because we didn't have a chance to look at the Constitution and amend it or make it more the way that we want it to be. But that's my opinion, and doesn't necessarily have anything to do with anything. So after the Civil War, they amended the Constitution, and I think my next person to read is Christian. Would you be willing to read at least section 1 of Amendment 13?
Sure. You ready?
Yep.
Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction.
That's right. That's right. That's right. So, so what has it's the abolition of slavery. That's why, because this was passed, that's why we can say, yeah, that's kind of what the purpose of the Civil War was. Even though there's all kinds of other things about that, there were economic reasons, and there were this and there were that, and it was state rights, and it was this, and all of those things kind of play into it. But after the war was over, this is what changed. So this is what that war was kind of about. It's just you can't really deny it. And this is 1865, right after the war concluded. And then now this is actually, it's a power that's granted to Congress. Most of the powers that are granted to Congress, or actually all the powers that are granted to Congress, are in Article 1, Section 8. There's a whole list of them having to do with post offices and all different kinds of stuff. When they did this, they recognized that this is a nice thing to say, that, well, we're not going to have any slavery, we're not going to have any involuntary servitude. That's real nice. But Section 2 is what gives its teeth. What makes it a new enumerated power, as though it were just part of Section 8. And so, Christian, you want to read that Section 2?
The enabling clause, yes. Section 2, Congress shall have the power to enforce this article by appropriate legislation.
Good.
Right, and without that, Congress would not have that power to write the legislation.
Correct. That's exactly right. That's exactly right.
Cool.
So, all right. Any comments or thoughts or anything about anybody want to say about that?
Well, yes.
Okay.
In involuntary servitude, does that include conscription into the armed forces under a draft system?
Apparently not, since they do it.
Right. Well, we got rid of the draft, I believe, under Reagan. But yeah, they sure were doing it in the 1960s, I'm here to say.
Yeah.
Yeah, well, yes, that's correct. So
if you do a little research on that, you might find something interesting about that. If you start using your Google Scholar and do a search engine on it.
Yeah.
On what exactly?
Google Scholar has all of your Supreme Court rulings, and it has a great search engine within it. So Google. If you have a question about something like the draft and the 13th Amendment, you might just Google those two things and see what pops up and what the Supreme Court ruled upon those items.
That's terrific. Google search.
Well, you got to go to Google Scholar, and then there's a search engine within that.
Okay. There was a libertarian. Thank you. That's good data. There was a conservative who went to court and was made the argument that his being drafted was slavery because he didn't willingly consent.
Voluntary.
It was involuntary servitude, and he lost the case, and he did hard time. I think about 18 months. I forget his name now.
Okay. All right. Moving on. The next section is the way that I look at this is the purpose of the 13th Amendment was to enable people to enable the blacks who used to be slaves to become citizens in the country. And one of the most important sovereign powers of a state is to determine who its citizens are. When Congress attempted to pass the Civil Rights Act of 1865, they had to name and say that blacks were citizens. However, they knew that when they were doing that, they were going to have problems with that because each state gets to determine who its citizens are. So they said, and they knew that they were going to have to amend the Constitution even as they were writing the Civil Rights Act of 1865, which parts of it are actually still in the U.S. Code. So they came up, so they realized, okay, what we're going to have to do is we're going to have to make a definition. We're going to have to define citizen for all states. We can't allow the states to define who a citizen is anymore. We have to, at least in this particular case, working this way, we have to do this. So, Howard, you want to read?
Sure. Section 1.
Start Section 1, and I may stop you at some point.
Okay, sure. Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside.
Good. Now, see, because at the beginning, if you look at the Constitution, if you read the Constitution, it talks about, for instance, a person to be a representative in the House of Representatives has to be a citizen of the United States. Well, actually, there was at that time no such thing as a citizen of the United States.
Right.
There was a citizen. Every state has had its own citizens, and when the state became a part of the United States, those citizens of the state became citizens of the United States at the same time. So, a citizen of the United States depends upon a person being a citizen of a state. And what was happening in the South is they were saying, oh, okay, you no longer have involuntary servitude, you're no longer a slave, but you're not a citizen either. So they were not allowed to vote. They were not allowed to give witness in court. They were not allowed to sue. They were not allowed to. They did not have any rights of being part of the civil rights. They had no civil rights, and I actually cover this quite a bit in my chapter on civil rights in my Your Rights book. Your rights, what they are, and how to keep them, or something like that. Anyway, so they drew up this. They drew up this Civil Rights Act of 1865, but in order to do that, they had to say, all right, you got to be citizens. And they realized they had to do a constitutional amendment to do that. And this is that constitutional amendment. It makes all persons born or naturalized in the United States and subject to the jurisdiction thereof. And that is where the rub comes, being subject to the jurisdiction thereof. Because that's under this, this is what this is what allows so-called anchor babies and so on, because jurisdiction has a number of different definitions. And And jurisdiction in this time, jurisdiction in this case meant having allegiance to the country, not just that you follow stop signs and stuff like that, because everybody's supposed to follow stop signs whether you're a citizen or not. You have, but because if anyway, that goes back and forth in the court cases, and I have my opinion of the way it should be, but I'm not going to do that. It hinges on the definition of jurisdiction. So anyway, they said, okay, now all of these freed blacks, they're citizens. That's what the purpose of this was, so that they could then have civil rights. And you want to continue on, Howard?
Yes. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws.
And equal protection I have circled there because it's been used to reapportion election districts, integrate schools, provide disabled parking, all kinds of stuff. There are court cases. Marty gave me sent me a very good book about Supreme Court cases, and it has in it a very good description. What's that called? What's the name of that book, Marty?
The Supreme Powers. Supreme Power.
Supreme Powers, right? And it describes 7 landmark cases, and one of them had to do with the expansion of this equal protection, and the expansion of another one had to do with the expansion of due process. Very fascinating. Very fascinating. Okay, anyone care to make any comments about this before we move on?
Well, yeah, this is, people often go into court and they start talking about their due process rights, and then they'll mistakenly say the Fifth Amendment when they're complaining to their state, and they're separate. This is, the 14th Amendment is your weapon against your state violating your rights. And before the 14th Amendment, you were at the mercy of the state courts in reality. So this is your one chance to take, this is where, when there's a statute in federal law called 28, it's under Title 28. It's called the 1983 suit. It's titled Deprivation of Rights Under Color of State Law. And it's for violations of the 14th Amendment.
Right. Exactly right. I think we're going to talk about that a little bit in when we get down to section 3.
Could you please title what?
Title 28.
Section
USC?
1983.
Section 1983.
Thank you.
Yeah.
And actually 81 and 83 are kind of tied together.
Oh.
1981, 1983. 1981, 1982, 1983. The whole section.
Neat.
All right. Howard, you want to do the next one? The next one is
Section 2?
Yeah.
Okay. Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed.
Good. Okay. So what this was a rewrite of Article 1, Section 2, which talks about how you do apportionment. And that had in it the thing about 3/5 of all other persons. So basically, it's a rewrite of that, removing the 3/5 of all other persons. However, then it goes on one step further. Go ahead, Howard.
Okay. But when the right to vote at any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof is denied to any of the male inhabitants of such state, being 21 years of age and citizens of the United States, or in any way abridged except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state.
All right.
Boy.
Anybody ready to explain that to me?
Well,
Okay.
it means that Confederates who took up arms against the federal government were not allowed to vote unless they made a petition and were pardoned for their bad rebellious behavior. So they were deducting citizens.
Actually, Howard, that comes down in section 3. This is a little bit different.
Oh,
This is a little bit different. What this one is it says, if you are the state of Mississippi and you do not allow your new black citizens to vote, your representation is going to be cut.
oh, in proportion.
In proportion to the number of people that you don't allow to vote.
Whoa.
Wow.
So it's a little, I mean, as I say over on the side, it's never been enforced because it's difficult to prove.
Right, because, well, also the 15th Amendment is what gives them voting rights, right?
Well, actually, no, the 15th Amendment doesn't give them voting rights. Oh, no, excuse me. Yes, you are correct. Yeah, we'll get to there in a minute.
But it was a setup for the 15th.
Yeah, right.
Well,
Well, actually, what this was at the time, what they're trying to do here is they're trying to get the states to allow these people to be citizens. They're getting, let them vote, let them bear witness in court, let them sue, let them be a part of the community.
Let them hold property.
And that's what they did. That's what they did with the 13th Amendment. They said, we're not going to have any more slavery. And the states came back and they said, yeah, okay, you can, okay, so you're not a slave anymore, but you're not a citizen. And then so they came back with the 14th and they said, oh, yes, you are a citizen. And in fact, if you don't let them vote, we're going to cut down your representation. And some other things. Well, they didn't do that either. So then they had to come back with the 15th Amendment and said, and yeah, you have to let them vote. And that's what the 15th one is. So, so it's like the Congress keeps coming back to these states, and the states keep saying, no, we're not going to do it. And they say, okay, we're going to try it this way. No, we're going to try it this way. No, we're going to try it this way, until finally, well, there's a whole story of how Reconstruction was finally ended, but we won't do that right now. But anyway, that's what this section 2 is saying. If you don't let them vote, your representation in Congress is going to get cut down. That's what this is.
Cool.
Now that has application to our present day, where some states have tremendous population who are not citizens. They are illegal aliens, undocumented workers, whatever the name is these days.
Yeah.
I'd love to see California's representation cut proportional to the non-citizens who are residents thereof.
Well, it's, and the thing is that goes back and forth because it does say representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in the state. It's the people in the state, and it doesn't say whether they're citizens or not.
Okay, good. It's covered there. All right, good to know.
It's covered there, and excluding Indians not taxed. Now, Indians not taxed. The reason they have excluding Indians not taxed because the Indians would come in, they'd bring their buckskins and so on, and they'd trade for knives and flintlocks and whatnot, and then they'd go back to their own territory, and they weren't counted because they weren't really in the state. They were just there for the moment, and then they were leaving again, and that could be applied to illegal aliens who are here only because they broke a law, and therefore they really shouldn't be here, and they need to be deported. Would be the argument.
That's exactly true. The Supreme Court has actually dealt with that and says if you're here illegally, the Bill of Rights does not apply to you. So they're here. They're not. It applies only to you're here legally, meaning you've gone through. You either are here as a resident legally,
Right.
be a green card or not. And if you're not here legally, then you're not supposed to be here. Therefore, you're not counted.
Right. And I see. I see. So that makes them that puts them in the category of Indians not taxed.
Correct.
Okay. I didn't know there was actually a Supreme Court case on that, in which case then we should do that. But then that means you have to ask, are you a citizen? Anyway.
Oh, that's can't do that.
Okay, we're going to be moving on rather than getting involved in that. And so I'm going to ask Joel to read section number 3, which Howard had alluded to earlier.
All right. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof.
Okay, good. All right.
So one of our governors couldn't be listed there.
So this is because people have asked me, and I did write an email about it, that if President Trump decides to invoke the Insurrection Act, because this is the Insurrection Act is kind of the enabling legislation of this. If he decides to invoke the Insurrection Act in Portland or wherever, and he says that that the mayor of Portland or the governor of Oregon was giving aid and comfort to those people who were rioting, to the insurrection, then and then of course they will go to court. But then they will, then if they lose, if he's able to make that hold, that they were involved in giving aid and comfort to this insurrection, then they will forfeit the right to be a senator, representative, or
Governor, mayor.
or governor, mayor, or anything else, because every one of them has to take an oath, to uphold the Constitution. That's in Article 6.
It says to support the Constitution of the United States. Yeah.
Right. So they could then be if he decides to go that way, and all of the people, Robert E. Lee and Jefferson Davis and all the rest of them fit in this category right here.
Andrew Johnson.
Why was Andrew Johnson?
Andrew Johnson was took over the presidency after Abraham Lincoln. Yet he was skittered around both sides of the Civil War, and his actions kind of pronounced that self for him after Lincoln.
Oh, okay. I
Wonder if this is partly because of that.
I know that Andrew Johnson did do
Johnson or Jackson?
No, Johnson.
Johnson.
Yep.
Okay. Joel, go ahead, finish the last sentence. But Congress.
The Congress may, by a vote of 2/3 of each house, remove such disability.
And that's what they did with Robert E. Lee, with all the rest of them. In 1898, they removed all restrictions against former Confederates. So
Wow, did not know that.
so anyway, that's how
Huh.
the president could invoke the 14th Amendment and be able to get to people who are in office who, if they are fomenting this insurrectional rebellion.
Yeah.
Okay. Kevin, are you ready, sir?
Yes, sir.
All right, section 4.
Okay. Validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services, and suppressing insurrection or rebellion shall be questioned, shall not.
Shall not be questioned.
I got it.
Okay.
Shall not be questioned.
Okay, good. So we at that point, so this means that if you had contracted with the United States in order to to be in the army or to sell them barrels of salted pork. This is where the term pork barrel comes from, by the way. But if you did that and your that debt that is owed to you from the government of the United States for that is not to be questioned. They have to pay it. Okay, go ahead, Kevin.
Okay, sorry.
But neither. I'm sorry. It's right there. Whoops, over. It's right there.
But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave. But all such debts, obligations, and claims shall be held illegal and void.
Good. So if you bet on the wrong horse in this one, there is no payoff.
Could I throw something out there?
Yeah.
It kind of harkens back to Section 3, but John Kerry was a commissioned officer in the United States Navy when he met with members of the North Vietnamese delegation. And if that would not be treason, what might treason be?
Well, he has to be charged for it. And he probably could have been charged under the Logan Act, but they didn't do it. Because that would not necessarily, well, yes, I can see that would be, I can see how you would see that as giving aid or comfort to the enemy. I can see that, but somebody would have to prosecute it, and nobody did.
We have a bunch of whips.
No comment.
Bad.
Okay. And coming back again, this one makes it an enumerated power.
Enabling clause.
So I'm gonna let Christian read section 5.
Okay. Section 5, the Congress shall have the power to enforce by appropriate legislation the provisions of this article.
Good.
Always necessary in every section that Congress gets power.
That's correct. Exactly right. And when we get to some of the later ones, you'll notice that that is not there, and it's makes interesting thoughts of why they aren't. Okay, we got one more I want to do before we leave today, and that goes back to Marty.
Section 1.
Yes, sir, ma'am.
The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude.
Boom. This is when they come back, and the states still didn't knuckle under with Amendment 14. So they came back and they said, boom, it is this way.
Were these all passed at the exact same time, or were they staggered?
No. 65 was right after it, and this.
Oh, I see. Years. Okay.
This one was supposed to have done it. This one was supposed to have said, here we are. But it didn't. So they said, okay, 68, we're going to do this one. They tried that. Still didn't do it. So they said 1870. That's this one here.
Okay.
Then in the election of 18 '76, they struck a deal and ended
Reconstruction.
ended Reconstruction if if the Democrats allowed the Republican to be president. It was a corrupt deal, and they left the blacks of the South to the tender mercies of the Klan and all the rest of it, and that's how we had the rise of Jim Crow and all the rest of that stuff. It's a very it was just a corrupt deal in 1876. However, here we are on the books. The right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of color, creed, race, color, or previous condition of servitude. And of course, Christian's favorite section in there, section 2.
Labeling.
It's my favorite section, Christian. So,
it's something that I started studying about 8 months ago, and it very, very enlightening.
Yeah. Congress shall have the power to enforce this article by appropriate legislation. Now, I have on the side, this increases the political population. There is an old rule of governance, of good governance, that has been well known since going back to the Romans at least. And that is that if you have a power structure and you want to I don't want to say undermine, but you want to take down an existing power structure because either you think it's corrupt or you don't like it or you're not in power and you want to put yourself in power for whatever reason. The way that you destroy or take apart an existing power structure is you increase the political population. If right now you only have, like for instance, if in this group it was only the guys could vote, and we have ladies here as well, and the ladies just have to follow along with whatever the guys say. We have a power structure that has been developed because of that, and we will destroy that power structure or take it apart if we then allow the ladies to vote. We increase the political population, and it takes apart an existing power structure.
We have a raised hand also.
I'm sorry?
Raised hand. Kevin is holding his hand up.
I'm sorry to interrupt, John, but I believe it was only males who owned land.
Say that. Say that.
Is that correct or incorrect?
Males
who are land owners.
Yeah, but yeah. In colonial times, there were some states that only landowners were allowed to vote. That's right.
Because it's framed as a gender issue, and it really was more of a group of people who were landowners, or at least also frame it as a group of people who were landowners, who in other words had a stake in the, you know what I mean, a stake in what to be.
Yeah, especially in the South, where large plantations were owned by very wealthy men who had control of the votes.
Right.
Oh, right. The South, the Democrat Party were slave owners. Right. Never mind. I'm sorry, John. I didn't mean to disrupt you.
Oh, no. I believe that was the case until about the 1830s in some states. And after the age of Jackson, it became more universal. Male suffrage became more universal.
White male suffrage.
Yes, yes, exactly.
Right. And every time that you increase the political population, there's going to be a change in the power structure. And this is certainly part of what they were aiming at, because in the South you had this power structure and you could take it apart if suddenly we had a whole bunch of new people voting. And that's part of what they were aiming at. I mean, sometimes it's good, sometimes it's bad. It depends on, I mean, the good and bad really doesn't enter into it. I think the only reason I'm really mentioning this is because this is an effect. When you do increase the political population, you are going to change the power structure. So you have to look at, do I want to do this? is this what I want to do? Does that make sense?
Yes.
Um, because
The argument today is the dreamers, the so-called dreamers who were brought here as children, had no choice in the matter.
and we're going to increase the political population for that. And so you need to look at who's trying to do that and what is the power structure that they're trying to undermine, and what is the power structure that they're going to put in its place, and do you like that or not?
Yeah, Biden says he'll do it within first 100 days.
Yeah, he's going to do a lot of stuff in his first 100
That's what he
days.
definitely said. He said specifically that one, though.
Okay.
Well,
So,
Yeah.
but my point actually in bringing this up was that although we're studying the Constitution, the reason that I teach this is because I am trying to teach and learn what good governance is, because good governance is and governance is in our hands. And the Constitution is an exemplar of what good governance could be. And you look at what it was that they were trying to do and stuff like this. And this is just one of those little irrefutable laws of governance, is that when you increase the political population, and it's been true back to the Roman times, it's been true all along. Every time you increase the political population, you are changing the power structure for good or bad, whichever it is, but you have to know that that's what you're doing. Okay?
Yeah.
Yeah.
All right. Any other comments? Because I'm ready to call it a day.
That's right.
Excellent job.
Yeah, thank you.
No.
yes,
Thank you, guys.
I'm good.
I hope to see you all back next
Time.
Sunday.
and Kevin, stick around for a minute, would you?
Will do.
Okay.
All right.
Guys.
Have a good week,
Bye.
folks.
Bye, y'all.
All right, thank you.
Have a good one.
Bye-bye.
Bye. How do I get out of this?